on the Maxwell.
Yes, there we go.
Okay, council, let's go on the record in Maxwell versus Roddy. This is file number 2514948. If I could have both council put your appearances on, please.
Good afternoon, Your Honor. Elisa Lentz for the plaintiff, Crystal Maxwell.
Brian Roach on behalf of defendant Stephen Roddy.
Okay, we're on the record today. I did receive a mediation report indicating that the parties had settled this matter. I also received a proposed consent judgment of divorce today. So, Ms. Lentz, did you want to take testimony from your client?
Yes, Your Honor. Thank you.
Ms. Maxwell, are you able to hear me okay?
Yes,
Can you raise your right hand, please? You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
yes.
Thank you. You can lower your hand, and Ms. Lentz, whenever you're ready.
Thank you, Your Honor. Crystal, can you please state your full name and spell your last name for the record?
Crystal Sue Maxwell, Maxwell.
And did you file a complaint for divorce on November 4th, 2025?
Yes, I did.
At the time that you filed the complaint for divorce, had you been a resident of the state of Michigan for at least 180 days?
Yes,
And at the time that you filed the complaint for divorce, had you been a resident of Kalkaska County for at least 10 days?
yes,
And Crystal, were the allegations contained in the complaint for divorce true at the time that you filed it?
yes,
Are those allegations still true today?
yes,
And Crystal, has there been a breakdown of the marriage relationship to the extent that the objects of matrimony have been destroyed and there remains no reasonable likelihood that they can be repaired?
yes, that's correct.
And Crystal, I apologize for the intrusive and personal nature of my next question, but are you currently pregnant?
No,
And Crystal, do you and the defendant, Mr. Stephen Roddy, share any minor children?
no,
Crystal, did you and the defendant reach an agreement as to the division of marital assets and marital debt?
yes,
And did you read the consent judgment of divorce that was prepared by my office?
yes,
Crystal, does the consent judgment of divorce accurately reflect the agreement that you and the defendant reached regarding the division of marital property and marital debt?
yes,
And Crystal, do you understand that as part of that agreement, neither you nor the defendant are receiving spousal support, and spousal support is forever barred, which means you may not return to this court at a later date and time and request spousal support?
I understand.
And Crystal, do you understand that if the judge grants the request for divorce today, you'd be waiving your right to a trial? And at trial, you could have done better, you could have done worse, or you could have done about the same as the content contained in the judgment of divorce.
I understand.
And Crystal, with that understanding, is it your request that the judge go ahead and grant the request and enter a judgment of divorce today?
Yes,
Thank you, Crystal. Your Honor, I have no further questions for Ms. Maxwell. Thank you.
Thank you. Mr. Roach, did you have any questions for Ms. Maxwell?
No questions, Your Honor.
Okay, and Mr. Roach, I'm assuming that since your client isn't present, that there's going to be no testimony from him and you don't have any objection to finalizing things without him being present?
That's correct, Your Honor. He's authorized me to go ahead and finalize this divorce today without his presence.
All right, thank you. So I've heard the testimony of Ms. Maxwell. The court finds that it does establish the grounds for divorce under Michigan law. I did have an opportunity to review the proposed consent judgment. I find that it's generally equitable and contains all the provisions required by statute. The court will grant the divorce, and I'm signing that judgment with today's date. So Ms. Maxwell, that means that as of today, your divorce is final. Ms. Lentz, was there anything further that I needed to address for your side today?
No, Your Honor, thank you for the time.
Thank you. Mr. Roach, anything further for the record today?
I just was going to ask how we're going to get the order, Your Honor. Will we receive it in the mail?
If we were provided return copies and a return envelope, which we were, we'll mail it back to whoever submitted it, and then they will distribute it.
Okay, were you able to hear that, Mr. Roach?
I caught that. Thank you.
Brian, once I get
Okay,
it, I'll
great.
send you a copy of it too.
Got it. Thank you.
Okay, thank you. All parties on this file are free to disconnect at this time.
Thank you. Have a good day, everyone.
Thank you.
Thank
too.
you.
different languages on your.
Oh.
I don't think I was here. Oh, no.
All right, Mr. Elhart, are you able to hear me okay?
I am, thank you, Your Honor.
Okay, and let's see, we have Mr. Glisson and Ms. Yates. If you can hear me, I need you to unmute and turn on your video.
Hello.
There we go. Okay, so let's, hold on one second. Let's go on the record in Yates versus Glisson. This is file number 2514916. And a few moments ago, Mr. Elhart, I did receive by email, I don't have a printed copy that I could sign, but I did get notice that there's a judgment that's been signed by both parties. Is that
It
correct?
appears as though that's the case, Your Honor. This case has gone through a number of fits and starts. It was reinstated a month ago. We just got the new summonses yesterday, but in the meantime, Mr. Glossom has been served some time and did agree to a judgment of divorce. So I'd like to put the proofs on and enter the judgment. The original has been sent to you, and I think everyone's in concurrence.
Okay, Mr. Glisson, is that how you wanted to proceed today as well?
Yes, sir. Thank you.
I do note that, Your Honor, there's a typographical. We have him spelled as Glisson, and apparently it's Glosson.
All right, sir, is that the correct spelling, Glosson?
It's Glisson.
Okay, then we had it right. It just shows up wrong on his screen, Your Honor.
Okay,
Oh, I do
All right,
see
so-
that. Sorry, guys.
that's okay. So Ms. Yates, I'm going to have you raise your right hand, please. Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you. You can lower your hand, and Mr. Elhart, if you would please take proofs from your client.
Thank you, Ms. Yates. It states within your complaint for divorce that you're a resident of the county of Kalkaska in the state of Michigan for at least 180 days. Is that correct?
You've been a resident for at least 180 days?
Yes, sir.
It also states that you were married on February 14th, 2012 to the defendant. Is that correct?
Yes, sir.
And you do not have any minor children?
No minor children, obviously.
No. No, sir.
You're not currently pregnant, are you?
Not currently pregnant.
No, I'm not, sir.
And your maiden name prior was Carla, Agrusa. Is that correct?
Yes, sir.
You state that there's been a breakdown of the marriage relationship to the extent the objects of matrimony are no longer possible. Do you believe this marriage can be saved?
No, sir.
Are you asking the judge to dissolve the marriage?
Yes, sir.
You've signed a consent judgment divorce, and the reality of life is neither one of you are claiming anything from anybody else. Is that correct?
I didn't get that. I'm sorry.
Your property settlement. You read your property settlement?
My mom is hearing impaired and I have the captions on, so it's taking a minute to
That's fine.
pop up on the screen. I'm sorry.
I'm sorry. Can you repeat that, please?
Sure. You read the property settlement, correct?
The property settlement, did you read it?
Yes, sir. I did.
And you understand that neither one of you have anything. No, the judgment divorce doesn't really have to divide any.
Yes, sir.
All right. And are you asking the judge to enter that divorce?
Are you asking the judge to enter the
Yes,
divorce?
sir.
You also understand that there's no provision within that for spousal support, and it'll be forever barred.
You understand that there's no spousal support?
Yes, sir.
Thank you, Your Honor. I have no further questions.
Okay, young lady that's been helping your mom there, can you tell me your name, please?
Jayla Yates.
Okay, and you've been helping your mom because she has issues with hearing, is that correct?
That's correct.
Okay, I just want to make that clear. If we have to make a transcript sometime later, they may wonder who the other person was, so I just need to make that clear for the record, so thank you. All right, Mr. Glisson, can you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. You can lower your hand. Mr. Glisson, did you hear all the questions that were asked of Miss Yates?
Yes, sir.
And did you hear all of her answers?
Yes, I did.
Do you have any reason to believe that any of the answers she gave were untrue?
No, sir.
And you understand that you would also not be receiving any alimony or spousal support, and that would be forever barred for you as well?
Yes, sir.
And you have signed the judgment of divorce, is that correct?
Yes, sir.
And by signing that, does that mean that you've read through that entire judgment?
Yes, sir.
And does that mean that you agree to abide by all the terms of that judgment?
I do.
Thank you. Mr. Elhart, did you have any questions for Mr. Glisson?
Nothing, thank you, Your Honor.
All right, the court finds that the statutory grounds for divorce have been met by the testimony of both parties. The court will grant the divorce. Once that's presented to me, I will sign it. So it's important for both you, Ms. Yates, and you, Mr. Glisson, to understand that the divorce isn't technically final until I sign that judgment. So it's important for you to follow up with Mr. Elhart to make sure that you get that once the court has signed that. Mr. Elhart, anything else we can address for your side today?
Nothing further, thank you, Your Honor.
Mr. Glisson, did you have any questions at all?
I do not. Thank you.
Okay, thank you. That's all for today, and all parties are free to disconnect at this time.
Thank you.
Okay, and I am going to call Graham versus K. That is file number 2514689. It looks like that case is settled. Neither party appeared for that, which was set for 145. I'm presuming because the matter is settled. So the court will not conduct any further scheduling in that case.
Oh, I jumped one.
What's that?
I jumped one ahead.
That's okay. All right, sir, I just need you to unmute, please. Should be a red button with a microphone. You just need to press that.
He's got to press, Brian's got to press it.
Yeah.
How come my face isn't showing up?
There we go. Mr. Berg, can you hear me?
Yeah. Yes, I
Okay. Ms. Smith, are you there?
Yes, I am.
I can't see you. I don't know if you have something going on with your camera.
I don't know. I can't get a picture.
Okay. All right, your voice is coming through good. So let's try and go forward then. This is file number 21-13761. It's Don Berg, now Smith versus Brian Berg. Both parties are present today by Zoom video. This was set for a hearing by Ms. Smith. And Ms. Smith, you're indicating that Mr. Berg is still not cooperating with the sale of the house. Is that correct?
Correct.
So we had a hearing, I believe, back in October. So what's gone on since October that is continuing to be an issue?
He agrees in the beginning and everything seems fine until later on he goes back to the way he was with me. I've had 4 realtors altogether, and I do have the numbers of 3 realtors that I could give you the number for witnesses. They told me I could. And one is a witness to all the garbage in the garage. And they both can state about how much the house is actually worth. And
Okay.
I had to serve eviction notices to the people he has living there. And he was trying to keep it secret from me. And the person that he has living there also got evicted from her other place because of garbage and police coming there. And she got her kids taken away because the house was dirty. And she's living in my house that I'm trying to sell.
Okay. All right, Mr. Berg,
And-
what do you say about that? Oh, I'm sorry. Go ahead. Are you? I thought you were finished, Ms. Smith.
Oh, and then as far as the property taxes go, I had to contact them so I can get copies of the bills. And I have my receipt of that I've paid more than half. I paid, well, I have the receipts. I paid a total of, where is it? I paid a total of $814 and he's only paid $2. That's what he said.
Okay.
I disagree.
Yeah, Mr. Berg, I'm going to give you a chance here in just a second. I just want to make sure Ms. Smith tells me everything that she wants to tell me first.
Yeah, I'm
So
just
can you state that last part again, Ms. Smith?
about the property taxes.
Yeah.
It went into arrears. because I paid one and he was gonna pay the next one that was due and he didn't. And it went into arrears. I had to go up there and I paid the 651 of that. And he told me he paid 200. And that's what the clerk said to me. And then I have another receipt for 162.54 that I paid in January of 25. Because that was my half from another one. So that's what I paid it. And he won't fix anything on the house to make it look better. And I have a receipt of my half of the privacy fence that we agreed to pay. And he didn't get his half. And I have the receipt for my half that's already up. So, let me see. Yep, and I have the number of the realtors that I can give you also if you want to speak to them as proof. Did you want those phone numbers?
Well, I can't just call up people and ask them questions. What we would have to do
Well,
is have a hearing.
Because I already talked to them today, and they said they'd be more than willing to, talk to you. So that's part of
And
my proof.
Sure, and I understand that, but I have a procedure that I have to follow in court. I
Okay.
can't just have informal conversations with people on the phone as a judge.
Okay.
Those people would have to come in and they would have to be sworn in, and Mr. Berg would have to have an opportunity to question them as well. So that's how things work in court. We can't just have informal conversations. I have to have evidence and they have to be under oath and testify, and both sides have to be able to ask them questions. So
Okay.
That's certainly something we can do, and they may be able to offer helpful testimony, but I have to follow the correct procedure. You understand that?
Yes. And
Okay.
Brian also, he wanted to leave it up to me to find the realtors to put a sign to sell the house. And he's complaining that I don't find the realtor, but it's both of us that have to sell the house, not just me. And I'm the one doing all the work.
Okay.
And the one realtor brought a guy out there, and he didn't even want to go in and look at inside the house, which is like nicer. All he saw was the outside and all that garbage, and he wouldn't even go in. And I got a cash offer, and Brian didn't want to agree on that. And it's been almost 5 years that the house has been up for sale.
Okay.
So it hasn't had a sign in
Okay.
front of it for a couple of months because of this.
Several months.
All right. Let me hear from Mr. Berg now. Mr. Berg, what's your side of this?
I have paid on the taxes when I was working for Grand Traverse Plastics, and I do have the receipts, and I'd also like to request a formal hearing in person so I can prove the documents.
All right. Well, that's one part of it. We could certainly do that. And I think, I think we're going to need to have a hearing here in person where Ms. Smith has some of these agents come in and testify, or at least one of them. But Mr. Berg, what's your side of not cooperating with selling this house?
As far as selling a house, I'm still willing, but I'm feeling that I'm getting lowballed on these offers. I do have the state assessed value of it, and it's assessed at just the taxes is like $56,000.
Okay. So what have the offers been?
I'm not for sure because I was never contacted by the realtor. I was contacted, but they never made the offer. They never explained the offer to me.
Well, then how do you know you're getting lowballed on offers if you don't even know what the offer is?
Well, what I'm saying is they suggested 70,000. And I know the
Okay.
house is worth at least 112,000.
So what you're saying is that the asking price that the realtors are suggesting you think is too low?
That is correct.
Okay. All right. Well, I think what we need to do is have a hearing. So Ms. Smith, if you have one or more of those realtors who is willing to come in and testify, then you're going to need to contact them. The court will give you and Mr. Berg notice of the date of that hearing.
Okay.
And you're going to have contact them and let them know and have them come in to testify. Otherwise, I'll just go on the testimony of what you both have. Also, both of you, to the extent that we have issues regarding the payment of property taxes and other issues, both of you will need to bring in whatever documentation you have of amounts that you've paid and so forth. And so, you know, I'm looking at the agreement that you guys made back in July of 2023. And it does indicate that you are to agree on a realtor who will sell the home. And after paying the cost, Mr. Berg will get 40%. In the meantime, you'll evenly split the cost of insurance and evenly split the cost of real estate taxes. So to the extent that Mr. Berg, that you haven't paid your share, you know, you're going to be required to do that, but you'll have an opportunity to bring in proof if you believe that you have paid your share. And I'll have to make a decision.
I do have.
Hello? Hello?
Just a second, Ms. Smith, is
Oh, I thought my screen went blank. I'm sorry.
yeah. No, it's hard because I can't see you either. So, Mr. Berg, you cut out there.
I do have the receipts for the taxes that I have paid. And also the people that were living here are no longer here.
Yes, if I may, I do
Yeah.
have eviction notices for the ones that were staying there. They're supposed to be out by April 11th. And if they're not, I got the eviction notices to file. Because they're not paying rent or anything.
Yeah, I mean, that's a whole separate issue from the sale of the house, but so I'll set this for the hearing. The court will hear what whoever shows up as a witness has to say, including testimony from both of you. And then I'm going to order that the house be sold. And Mr. Berg, I mean, to the extent that you're not cooperating, you know, I tend to agree with Ms. Smith. This has been going on for a long time. We were back here in April or last October. You said that you would cooperate. This house needs to get sold, and it is going to get sold. The only thing that we're going to be doing at that hearing is whether or not the real estate agents have an appropriate selling price and listing price and so forth. So
when the realtor, the last realtor that come out here, she said she would get back with us, and she never did.
She brought a guy out here to look at the place.
That was a gentleman that was looking at the house to purchase it.
He didn't even want to come in. But
all right, this isn't really a time for the two of you to argue back and forth. You can do that outside of court. I'm gonna I'm gonna set this for a hearing. You can both testify and I'll determine who is more believable. You're both telling very different stories, so I'll have to make a determination based on your testimony and the testimony of any realtors. And again, Ms. Smith, I would highly recommend that those individuals that you've indicated are willing to testify, that you make efforts to have them come in. Otherwise,
Oh, I can't hear you.
I'm gonna have to just go on what you have, the CERC has to say. So, all right, the court is gonna set this for a hearing. The court will send out notice of the date and time of that hearing to both sides. Again, you need to bring whatever witnesses and whatever evidence you both have to that hearing date. That'll be the only date for the hearing. So if you don't bring evidence, then we'll proceed without it. I won't adjourn it or set another date after that because this needs to get taken care of and over and done with. So, again, we'll provide notice of the date and time of that to both of you. Ms. Smith, do you have any questions?
No.
Mr. Berg, do you have any? Go ahead.
My eviction, never mind. That's fine. Okay, I'm good. Sorry. I'm fine.
That's all right. Mr. Berg, do you have any questions at all?
No, sir, I do not.
Okay. All right. Thank you. That's all for this hearing today. Again, look for that notice and both sides are free to disconnect at this time.
Okay, thank you. I don't know how to disconnect. There's my sister.
No.
Shepherd.
Their case number.
Oh, that's helpful
It's so much easier.
instead of guessing.
Okay, Mr. Sasan, you're appearing on behalf of Kalkaska Memorial Health Center, is that correct?
I am, Your Honor. Yes. Good afternoon.
Okay, 1 second here. Okay, we'll go on the record in Kalkaska Memorial Health Center versus Faribault, file number 2615028. The record should reflect that counsel for plaintiff is present by Zoom, and sir, you're Jeffrey Faribault, is that correct?
Yes, sir.
Okay, Mr. Faribault is appearing today, and Mr. Faribault, do you have an attorney in this case?
I do not, Your Honor.
Okay. All right, so we're on the record in this case. This is the first hearing. This is a scheduling hearing to set some dates for going forward. Mr. Sasang, just want to get a sense from you. Have you had any discussions with Mr. Faribault? Is this something that we can, have mediation or something like that to attempt to get it resolved early on? Do you want to set a lot of dates in this? How did you want to go forward with scheduling?
Thank you very much, Your Honor. I have not, in answer to Your Honor's question, had an opportunity to speak with Mr. Faribault, and I certainly am willing to, following the hearing, or if the court wants to place this in the breakout room. However, that being said, I do understand that the defendant has filed an answer to the complaint. And, Your Honor, the defendant's answer to the complaint plainly indicates that he does not dispute the medical expenses that were incurred. He's not disputing the amount that's being sought by plaintiff. Although he outlines his difficult financial situation and medical situation as an explanation, he does outline his lack of financial resources to satisfy the debt. It is plaintiff's position, that being said, first and foremost, technically the answer fails to comply with court rule by answering plaintiff's allegations as set forth in each paragraph of plaintiff's complaint. Number two, along with the defendant, he's not filed any affirmative defenses to plaintiff's complaint. And given that he plainly admits owing the medical expenses in his answer to the complaint, I don't know if the court would consider, but plaintiff would orally make a motion for entry of judgment as a matter of law pursuant to Michigan Court Rule 2.116I1, which does provide that if the pleadings show that a party is entitled to judgment as a matter of law, or if the affidavits or other proofs show that there is no genuine issue of material fact, the court shall render judgment without delay. Again, given the defendant's answer to the complaint, his failure to dispute his admission, and the fact that the defendant's not filed, raised, or asserted any affirmative defenses to plaintiff's complaint, plaintiff again would orally motion for entry of a judgment as a matter of law under that particular court rule. Thank you.
All right, so I guess what I would say then, and I did read through Mr. Faribault's complaint. Number one, I'm not going to grant any kind of relief here today. This was set as a scheduling conference. I wouldn't expect Mr. Faribault, or if he was represented by counsel, to be prepared to contest a legal argument or present a legal argument for why a default shouldn't be entered. And that's not to say, Mr. Sasson, that you don't have good arguments. I just don't think it's fair to grant a default or a judgment here today in the context of a scheduling conference. When I don't think either side would have been prepared for something substantive to happen in the case at this kind of hearing. So I'm going to simply set a period of discovery of 90 days from today's date. Mr. Sasson, if you want to file a motion for entry of a default and default judgment, then I'm going to ask that you file that within the next 30 days and notice that for hearing. And that way, Mr. Faribault will have an opportunity to contest that or to retain counsel to help him if he wishes to contest that. If it's not contested, then we'll take it up in due course. And then if the court were to grant that, I think we then would be a matter of collections. But again, I want to give Mr. Faribault a full and fair opportunity to address that. So that's how we'll go forward. And the court will set it for a status conference at 90 days. So if for some reason there isn't a motion for default filed or isn't further proceedings, then our next hearing will be in about 9 days. And that would provide a period for discovery to the extent Mr. Sasson or Mr. Faribault has any discovery that they would like to engage in. I will send out a scheduling order that reflects those dates. So Mr. Faribault, you'll get something from the court showing that along with the notice of the date and time of that status conference at 90 days. If Mr. Sasson files that motion for default, then Mr. Faribault, you'll get notice of that hearing as well. And Mr. Sasson, if you can set that for a hearing by Zoom as we're doing today.
Very good, Your Honor. I will do that.
Mr. Faribault, do you have any questions at all about what we've talked about or how we're going to proceed?
No, sir, I don't.
Okay. Mr. Sasson, is there any other matters I can address for your side today?
Not for plaintiff. Thank you, Your Honor. Is the court able, though, to place Mr. Faribault and I in a breakout room to speak?
I can certainly do that, Mr. Faribault. Are you willing to speak with Mr. Sasson here today?
I don't want to do that.
Okay. All right. So I'm not going to do that.
Thank you.
And so I will leave. I'll leave the parties to decide how they want to proceed within the confines of the court's order for scheduling here today. And both sides are free to disconnect. Thank you.
Thank you very much, Your Honor. Have a nice day. Thank you, Mr. Faribault.
Thank you.
Hi, Counsel, Mr. Shepherd. I see you have listed as attorney for Forefront. I'm just wondering, what is the case number? I have one file left this afternoon, and I don't see Forefront listed as a party.
Sure. Your Honor, the case number I have is 25-14990 PD. And that's Forefront v. Scott Peters.
Okay, let me take a look here. Our clerk's going to take a look here because I don't have that one on my docket.
Okay.
We're just going to take a look at the ROA here and see what it shows.
Okay.
don't see anything having been scheduled. I can go grab the file. Yeah, I don't have any hearing date information.
I submitted a entry of a default judgment in a claim and delivery matter. And in lieu of getting it back entered, I received a hearing date for a motion for entry of default judgment.
Okay. Can you contact Jennifer at my office and
Absolutely.
find out something may have gotten crossed, or she may have gotten you a date and, but it didn't get put on the docket. So if you can contact her, we don't have it on the docket, and no opposing parties are present either.
Okay, absolutely. I'll reach out to Jennifer.
Okay, thank you.
Thank you, Your Honor. Have a good day.
You too.
Morning, Your Honor.
Hello. All right, we've got both parties. We'll go on the record now in Grillo versus Oliver. This is file number 2514984. If I could just have both counsel put your appearances on, please.
Ryan Lawson from Sinus Stramus Law Firm for plaintiff.
Good afternoon, Judge Mark Mueller on behalf of defendant Oliver.
All right, thank you. Mr. Lawson, can you kind of just give me a quick rundown of what your claims are and the relevant facts in this case and what you would like to see for scheduling going forward?
Yes, Your Honor. It's a car crash that occurred on March 14th, 2023 in Kalkaska, in the city of Kalkaska. The defendant, per the police report, ignored a yield sign, drove into an intersection illegally, and caused a T-bone type collision with my client. My client had previous neck surgery, and since the crash has experienced post-concussive syndrome, aggravated neck issues, left shoulder issues, as well as emotional and mental sequela from both the pain and the head injury.
Okay, thank you. Mr. Mueller, are you contesting liability and damages, or what's the defense position kind of on this?
You know, quite frankly, Your Honor, it's pretty early in this case, and I haven't even spoken to my client yet. So on its face, I don't think it's going to be a disputed liability case, but I'm not here to put an admission of liability on the record on behalf of my client, at least at this juncture, Your Honor. But I do think the main focus will be on the injuries and the treatment.
Okay, all right. Is there anything novel about this case, or that would take us outside the realm of what would kind of be a normal, I guess, scheduling order in this case, Mr.
Judge,
Lawson?
What is your normal discovery period, Judge?
I think it's something like this. I would start with 6 months of discovery with mediation to occur sometime within that 6 months. I would typically set a dispositive motion cutoff for 30 days following the close of discovery, and then set it for a status conference at or about the close of discovery or at the time of dispositive motions. And then see where things are at. If the case wasn't successful in mediation, then we could, discuss further ADR or get it on the trial track at that point.
That sounds
So that's
fine.
kind of what I would. Okay.
And
all right, Mr. Mullen.
Yeah, that's acceptable, Your Honor. 6 months is approved by the defense. And while we're all here, Brian, I would recommend Matt Coffey as a mediator.
Where is he? I don't know, Matt.
He's out of the Saginaw area. If you want to ask around about Matt, please do so. But I think you'll find from your colleagues that he's well respected and highly used.
Well, if you like him, I'm sure my folks will like him. Is he plaintiff or defense? What's his background?
His background is defense.
Good. I prefer to use defense lawyers.
But okay. But his primary practice now is, I think, almost close to 100% mediations. He's so busy.
Okay. Let's give it a try. Sure.
Okay.
All right, I'll note in the order, again, who was it? I missed the name.
Matt Coffey, Coffey.
Okay, I'll note that in the pretrial order.
Mark, would you be willing to send Matt the caption and see if he's has any conflicts?
Yeah, I'll have my assistant do that.
Perfect, thank you.
You're welcome.
All right, Mr. Lawson, any other dates that we haven't discussed that you'd like included?
Nothing I can think of, Your Honor. I know Mr. Mueller and respect him, and I think we should be able to work through this in a pretty standard fashion.
Yeah.
Okay, Mr. Mueller, any other dates you'd like to request?
None, Your Honor.
Okay, so I'll put the dates that we've discussed here into a pretrial order that'll go out to both of you. Also, the court will send you notice of the date and time of that status conference in about 6 months. And both parties are free to disconnect. Thank you.
Thanks, Judge.
Thank you, Judge. Thanks, Brian.
See you, Mark.
All right, that concludes our afternoon docket. The court will